Hey everybody, this is Charles Raether at AmLaw Group. Today we have another interesting case study we wanted to talk about. This one we're focusing on E2 for UK residents. So I guess I can't say, but I would say number one demographic for our E2 practice are Canadians. UK citizens, probably in the top 3 or 4, I would say, in terms of nationalities. And so today I wanted to talk about one UK application that is kind of typical for UK residents. And if you hear this case study or this client study and it kind of resonates with you, I think it shows that, hey, this is a common thing. People are regularly doing it. It's not overly difficult as long as you do it correctly with experienced legal assistance. So we had one gentleman, he was interested in a property management company in Florida. I never clarified how he found out about this business. He might have worked with an agent, might have worked with somebody else. I believe the seller of the company was actually a British national, so it's quite possible maybe through some ties back in Britain, he found out about this person who was selling their existing property management company. Now, our British client had no previous experience in property management, so that goes to show you don't necessarily have to have a lot of years of experience or even any experience in that business that you're planning to launch in the US. So there's no requirements in that regard. And so I bought this company roughly for about $150,000. He primarily bought the assets because with a property management company, there's, you didn't want to have the exposure if you bought the shares of the company, if you did a share sale. And for that reason, he just bought the assets. And the assets are primarily the existing contracts, the client lists, goodwill, stuff like that. So it was roughly about $150,000 he paid for the business. Now the business, just to give you a rough ballpark, I think, revenue, net income of that business was maybe in the 50s, maybe $55,000 a year. So it was a ratio of about 1 to 3. That's pretty typical for these small size, service businesses that we see in the E2 field. So again, in terms of the financial investment, et cetera, it was a pretty typical investment. What was unique about it, I say unique in that we've done it before in the past, but it doesn't happen a lot of times because you really have to have an amenable seller. But what was unique is the seller agreed to make the sale contingent upon him getting the E2 visa. So how did we do that? We structured an escrow agreement. We created an escrow agreement. The closing attorney that was handling the closing of the business, the sale of the assets, also served as the escrow attorney for the E2. And the E2 escrow agreements said the following. It said, okay, prior to filing for the visa, the buyer will deposit in the escrow account the full purchase amount for purchasing the assets, roughly $150,000, I think. And our client would go to the interview for the E2 visa approved. Then at that point, the money would be debited from the escrow account and go to the seller. If the buyer got a denial, the buyer would have gotten all of his money back with maybe some small fees, for legal work or something. So this is an ideal situation where you as the E2 investor are almost fully protected from the unlikely event of getting a denial. And if you do get a denial, that's a pain in the butt, to put it mildly. That's the legal term we use. You have a business now that you own, but you can't necessarily come here and run and operate it. So for our client, this was an ideal situation. I'll have to admit, sellers generally are not willing to agree to that kind of scenario, but in this case, did agree. And so the client was able to minimize his downside, his risk in the unlikely but possible event that he would have gotten, a denial for the E2. So just to let you know, this was a great example of, where you didn't have to spend a real lot of money for buying the business, $150,000. We generally recommend about $100,000. And on top of that, the client was able to negotiate with the seller a deal where he would basically get his money back if he got a denial for the visa. We can't guarantee every seller would agree to that, but it's always something worthwhile, worthwhile keeping in mind. And I think a lot of sellers, in this market, if they're having a problem selling the business, they would agree to those terms. Create a delay of maybe 2-3 months in terms of the closing until you have the interview at the embassy. But nonetheless, if you have a motivated seller, I'll likely agree to that. So I hope this was helpful in giving you a little insight as to how you can structure these E2 deals. Each structure is maybe a little different. There's plain vanilla ones that we use all the time, might have an escrow structure, other way that we, in any case, this was an example of, and if this sounds like something that would be of interest to you and your family, please reach out directly to us and we can discuss how we could be of assistance to you as well.